So good morning. My name is Mary Holland. I'm a research scholar at NYU School of Law. I've been there for 13 years. My views don't necessarily reflect those of the university. I teach foreign lawyers basics of American legal skills. And for the last several years, I've been writing law reviews and co-edited and authored a book on vaccines. I'm working on another book about vaccines at the moment. I have a kind of diverse legal background, having worked in a federal court, international human rights organization, several large law firms, taught at Columbia and NYU. And I'm here today to testify before the California Senate Judiciary Committee against Bill 277. And I'm doing that on 4 legal bases. I know that the health and educational issues have been focused on in 2 prior committees. I'm really trying to focus on legal issues. And in my testimony today, I will focus on 4. The issue of informed consent to medical procedures, the issue of California's fundamental right to a public education, the issue of federal and state rights to equal protection and non-discrimination, and the requirement that the legislature mandate vaccinations, not administrative agencies. My view is that the current law, which is AB 2109 as embodied in law, is working, and it strikes the appropriate balance on these 4 factors. My view is if it's not broken, don't fix it. SB 277, by contrast, does not strike an appropriate balance. It is draconian in its effect, and I don't believe that it will survive a challenge in the courts, which is likely, should it be passed in its current form. So I'm prepared to talk briefly about those 4 factors, and then I'd be happy to answer questions. So very briefly on the 4 factors, the universal standard in the world for medical interventions is prior, free, and informed consent. That's the standard for all medical interventions. It was embodied in the Universal Declaration on Human Rights and Bioethics in 2005. It was a UNESCO declaration. The United States and over 190 other countries endorsed it. They specifically considered the issue of vaccination, and there is no carve-out for vaccination. So the issue of informed consent is fundamental for vaccination. The World Health Organization also has policy edicts on informed consent. My view is that existing law in California does provide for informed consent. It is not free informed consent, but it does give parents a meaningful choice. Parents who absolutely are unwilling to fully vaccinate according to California's schedule have the option to assert an exemption under existing law. Under 277, the only opt-outs are homeschooling or a medical exemption. In my best judgment, those are illusory opt-outs. Medical exemptions are exceptionally narrow. Doctors will lose their licenses if they really go with their conscience and if they don't follow exceedingly narrow limitations by the Centers for Disease Control and Prevention. And homeschooling is simply not an option for most mortal parents, especially for children with special needs, and a very significant percentage of those who assert exemptions are special needs children. My second issue with SB 277 is the California fundamental right to education. So unlike the federal Constitution, the California Constitution asserts that the right to an education is a fundamental right. So in order for any law to restrict that right, courts in California will have to look at that California right with strict scrutiny. What that means is that the government will have to show that it has a compelling state interest in order to restrict the right, and that the manner in which they're restricting it is the least restrictive means possible. Unfortunately, as the ACLU letter of concern notes, the current bill from Dr. Pan and Mr. Allen gives no justification whatsoever that the state has a compelling interest in barring those who assert personal belief exemptions from school. So with no justification, it's hard to see how SB 277 meets the threshold of a compelling state interest. And it certainly seems unlikely that barring children who don't fully comply with the vaccination schedule will be the least restrictive means possible. In particular, I think that SB 277 also presents severe challenges with federal educational rights under the Individuals with Disability Education Act. Under that, special needs students are entitled to a free and public education. That often includes a host of services. It includes socialization. It seems extremely unlikely to me that SB277 in its current configuration could possibly meet the requirements of federal law. And furthermore, enforcement would seem to be extremely difficult for 277. Those parents who are going to be in the hearing room today are parents who feel deeply that vaccinating their children would violate their children's best interest. Rightly or wrongly, those parents believe that it would violate their covenant with God or with their conscience to vaccinate the children. And this minority of parents has existed for the last 300 years. And I don't see how SB 277 is going to deal with that minority who simply will not vaccinate their children because it would violate what they perceive to be the children's best interest. It's unclear, will the schools then, or will the Department for Children's Welfare remove children and force vaccinate them? If they are forced vaccinated and there's an injury, will the state bear any liability, or will they just say, oh gee, we're sorry? Will the state be willing to throw non-vaccinated parents into prison? Those are some of the suggestions that have been raised in the last few months. I don't see what 277 will do. In any event, certainly there will be legal challenges, which I'm not sure that SB 277 would meet, and enforcement costs would be great. It seems to me that current law provides the steam valve that's required to keep the peace. The numbers of people who assert personal belief exemptions in no way threatens herd immunity. No parent is exempting their child at this point from ignorance or from laziness, which I think is what the 277 is designed to prevent. It seems to me that current law is working. We should go with what's working. My third legal point is discrimination and equal protection. And let me just point out that under that second point of education, I'm focused on California law. The other side may focus on federal law. I would concede that under federal law, the issue is not as clear-cut. Under California law, it requires strict scrutiny. The state has to have a compelling interest, and the means must be the least restrictive possible. That's clear. Third issue, discrimination and equal protection. I think it's clear that SB 277 blatantly stigmatizes and discriminates against the small minority of parents and children who choose not to fully comply with California's mandates. SB 277, unlike existing law, would create a new 21st century Jim Crow. It discriminates against children on the basis of a biological status, not on the basis of any imminent health threat. And it's hard to see how this biological status of not being in full compliance with California's vaccine mandates is distinguishable from other biological characteristics such as skin color, ethnicity, gender, or sexual orientation. There's a letter that was sent to all legislators by immunologist Dr. Tatiana Abukhanish, which clearly reviews vaccine by vaccine why children who are not in full compliance pose no greater risk than any other children. And indeed, specifically to prevent discrimination, federal law requires that HIV-infected children and children infected with hepatitis B be able to attend school. Those children, in fact, do represent some risk to the public health, and yet, in order to preserve their right to education and to prevent discrimination, they are allowed. And this law would suggest that children who pose no risk whatsoever would not be able to attend school. And I think it's important to remember that in the event of any disease outbreak of a vaccine-targeted disease, schools have every right to force those children to stay home. And that's been working in 48 states for 50 years. So the schools today do have levers to protect the public health, and they work. Furthermore, SB 277 is a slippery slope. If the state is willing to deprive children of a public education for their vaccine status, what's next? Is it water fountains, restrooms, restaurants, hotels? We know in America that separate but equal doesn't work. Let's not repeat our mistakes of the past for the greater good today. I think that existing law in California does strike the right balance. I think it's more restrictive than it was. I think it certainly weeds out any parents who, for laziness or ignorance, would choose not to vaccinate. What it protects right now is those parents who have a deeply held religious or conscientious objection to vaccination. And in the event of outbreaks, those children must stay home. Fourth legal factor of what's wrong with SB 277 is line 11, which suggests that the legislature would hand over all decision-making on future vaccine mandates to the Department of Public Health. That is not in compliance with federal law. Under Jacobson versus Massachusetts, the U.S. Supreme Court's landmark decision, which permits vaccine mandates in the context of imminent threat to the public, those decisions have to be made by the legislature and by the people's representatives. And that's the notion that if the people's representatives get it wrong, they can be voted out of office. The Department of Health officials are unelected and they're disconnected from politics. They can't be thrown out of office. I think it would be legally challengeable and politically unwise to give all responsibility over vaccination issues to the Department of Health. And I don't understand why the legislature would choose to abdicate its responsibility in this area. I think for all of these reasons, if SB277 goes forward in its current form, it will undoubtedly be challenged in the courts, and I think it will wreak havoc. I think there will be multiple lawsuits throughout the state, and I think it's quite likely that there would be a temporary restraining order placed on enactment of the law pending a full hearing in court on whether or not this law actually meets a compelling state interest and whether it provides the least restrictive means possible. All of that would cause great confusion and distress among children and parents in California. So I will urge the Judiciary Committee not to pass the buck and to protect the courts that it's sworn to do. Jacobson, the landmark decision, specifically said in 1905 that courts are required to step in when mandates are arbitrary and oppressive. It seems to me that this Judiciary Committee should not make the courts do its work. So that's basically my 4 points, and I'm happy to answer any questions.
You had mentioned that that this is challengeable in court. There are 2 states that have very similar vaccination laws. Can you speak to that?
Yes.
And why those are, work in those states? And
yeah, so those 2 states are different. First of all, West Virginia and Mississippi are the 2 states that have no non-medical exemptions. Neither of them has ever had religious or personal belief exemptions. So this situation is unique and different. We will be depriving people of rights that they already enjoy. Mississippi does not have a constitutional provision providing for a fundamental right to education. So that's different. And West Virginia, although it has that, I think it's not the same issue as taking this right away in California. I think also California law is very clear in the Serrano v. Priest case that it must be a compelling state interest, which has not yet been shown. So I think it's a different, and also the cases that were litigated in West Virginia that went to the Fourth Circuit, the case in New York, they're on a different issue. They're on a religious exemption. In California, we have a broader exemption today, the personal belief exemption. So I think it's a different case, and I think that it will have a different judicial outcome.
there's been talk about, in terms of the religious exemption,
Yeah.
Would it be adding a religious exemption to this bill solve any of the problems that you see in the bill?
I don't think that's on the table right now. What I see are serious legal problems with what's been proposed. My view is that the existing law works. It works. The SB277 works for people who have religious objections. It works for people who have deeply held personal convictions at the level of religious convictions. This is not allowing anybody to, through ignorance or laziness, opt into personal belief exemptions, which I think is the concern.
Both lawmakers have said that the religious exemption is something that they'd consider. You said it's not on the table, but if
Both lawmakers, you meaning?
Both Pan and Allen have said that they've never been opposed. It's something that they will, look at. So would that solve the issue of some of the legal challenges if they added it?
Well, it would depend on what the language was. I'd need to review any legal language. I think it's encouraging that they are open-minded, but I think that the legal challenges, I don't see why a religious exemption would be preferable to what California has today. I think that most often, in some of the states with religious exemptions, such as where I'm from, New York, the religious exemptions are too narrow, and they often do not provide adequately for atheists, for people who are agnostic, for people who are not in traditional churches that might have tenets against vaccination. So there are certainly potential problems with the religious exemption, and one would need to look at that language carefully.
I imagine you looked at the makeup of this judicial committee.
Yes.
What are your thoughts going into it, just given the number of people on this committee who have either previously supported or are signed up as a sponsor or a supporter of this bill?
Right. So my understanding is that there are 7 members of the committee, 5 are already on record supporting SB277. Many of them are lawyers. I'm sure that they're thoughtful people. I'm sure that they actually are acting out of the best of intentions and that they seek to enhance the public health, and I respect that deeply. My job is to educate them on what I see as the legal problems with this bill. And I hope that I will be able to at least raise questions in their mind.
Do you think that, given the 3 committees that this has gone through, first being health, education, and now the legal aspects of it, do you think that the legal aspects are some of the stronger counterpoints to SB 277?
I certainly think the legal ones are very serious because the legal challenges will go to the courts. So there will be second guessing the Judiciary Committee's work. If this law is half-baked, as I believe it is, it seems to me it's the job of the Judiciary Committee to nix it now. So in that sense, there's an immediate review. There's judicial review that's available. So it's a different kind of challenge. But I do think that the issues that were raised in the Health Committee and the Education Committee were very serious issues. I do think this is a far more serious and complex issue than it's often represented as being.
I'm not stealing all the questions.
No, you're good.
No, they're good questions. Well done. You've done some homework. That's great.
Just in terms of the legal challenges, what would be the process for?
Yeah, I think there could be multiple challenges, which is part of the problem. I think that parents who have special education students and have rights under federal law would be challenging under IDEA and under a free and public education. I also think that there will be those who would challenge this on California constitutional grounds. So this would be a challenge against the California Department of Public Health, and it would be, I would assume that there would be a challenge to get a restraining order against the enactment of this law. And that would be very, very problematic because it would really put everybody in limbo. What's going to happen? Where is my kid going to go to school? Do I have to leave my job? How am I going to pay for this? I think that would be exceptionally disruptive to the thousands of families who are affected by this. This affects, I don't know the exact number, if anyone does, but this is going to affect hundreds of thousands of people who have, I don't know how many it affects.
It's 13,000 for this year.
13,000 have asserted personal belief exemptions in the whole state.
Yeah.
Okay, thank you. So 13,000. So that's thousands of people. Yeah.
What specific court would, would it be parents that would go after the restraining order? How does that process work, and what court would they file?
Well, parents would file on behalf of their children, and they would file in a state court. They would file in a state trial court in their school district. Well, they probably would have a choice whether they would do it in near the state capital or in their home school district, but they would file in a state court.
Against the state or against the school district or both?
I believe it would be against the once it's enacted, it would be against the Department of Public Health.
About liability and stuff, being that the vaccine manufacturer is not held liable, if this becomes a state mandate, would there be any potential of the state actually being held liable in any form if they're mandating this?
So, under federal law, vaccine manufacturers and doctors who administer federally recommended vaccines have virtually no liability. Any claim for injuries from vaccines must go first to the National Vaccine Injury Compensation Program, which is an administrative program under the Court of Federal Claims in Washington. And there are a number of problems with that. But so to answer your question, so long as it's on the ACIP recommended schedule, the Advisory Committee on Immunization Practices, it would not trigger liability. I think there would be different issues, and I think there would be litigation if a child were to be removed by the state under SB 277, which it seems to me is the logical conclusion of this trajectory. If a child were removed from the parents and force vaccinated and the child suffered injury or death, I do believe there would certainly be lawyers and parents looking for ways to hold the state accountable. That's an issue that, although child removal has been litigated on this issue, rarely is it ever done purely on the issue of vaccination status alone. It's typically done in the context of broader medical or what would happen in the event of injury, I think is an open question.
Are you familiar in terms of with medical exemptions, what qualifies, what doesn't, how much leeway doctors are given, and is that by state?
So Dr. Zandfleet will be testifying today, a California doctor, about medical exemptions. And I think the issue of medical exemptions is very important. So I think in her testimony, she will explain that most doctors would not, they would not vary from what the Centers for Disease Control and Prevention recommends. And I'm aware if you look at the CDC website, what they consider to be invalid contraindications to vaccination include adverse events to a family member. So let's say a family has an older child who has died from an adverse vaccine reaction. That parent may not assert a medical exemption not to vaccinate the next younger child with the fear that they have a biological susceptibility. Similarly, the invalid contraindications include multiple vaccinations at one time. So let's say a new child comes into a California school district and is not caught up on their vaccines, and the parent says, I'd like to spread this out over 4 months. I don't want to give my child 10 vaccines today. That would not be a valid medical exemption. So I think in real life, doctors, in order to protect their licenses, are going to be extremely cautious about granting medical exemptions, and that's what we see around the country. And so unfortunately, because I think doctors will be second guessed by the Department of Public Health, that's what we've seen in West Virginia, I think that medical exemptions do not provide a real option to say no to vaccines. And I think that the hallmark of ethical medicine is the right to say no to unwanted medical interventions, and I don't believe medical exemptions provide that.
Great questions.
Yeah, excellent questions. I hope that the legislators are as on the ball as you are.